All rise. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 18th Circuit is now in session. All you having business in this honorable court, come forth and you shall be heard. God save the United States and this honorable court.
You may be seated, please. And good afternoon. Welcome to everybody. This is the case of John Keating Appellant versus Welton Elementary Public School, Springfield Public School, and Michelle Hodge. I want to welcome everybody to the Moot Court finals. The judges today, immediately to my left, is the Chief Justice of the Nebraska Supreme Court, Michael G. Heavican, and to my immediate right is the Honorable Francie Riedmann from the Nebraska Court of Appeals. My name is Judge John Gerrard, and I'm from the United States District Court here in the District of Nebraska. Counsel, are you ready to proceed? All right. Appellant, you may proceed.
May it please the court. Your honors, opposing counsel, my name is Shivani Sharma, and along with my co-counsel, Mr. Sean Danehey, we represent the interests of the appellant, Mr. John Keating. At this time, I'd like to reserve 90 seconds for rebuttal. Dedicated, demoted, dismissed. Your honors, this case is about a dedicated man. Mr. Keating was dedicated to his students, dedicated to his mother, and dedicated to his religion. Because of that, he was demoted and subsequently dismissed. Your honors, I will be discussing the Family Medical Leave Act claim, and my co-counsel, Mr. Danehey, will be discussing the First Amendment claim. And we respectfully request that this court reverse and remand the district court's determination on both claims under de novo review. Under the FMLA, a prima facie case for a retaliation claim consists of 3 elements. The district court determined that Mr. Keating satisfied the first element because he did in fact exercise a protected right. However, the district court erred in determining that Mr. Keating did not satisfy the second and third elements of the prima facie case. I will be discussing how Mr. Keating did in fact satisfy the second and third elements of the prima facie case because he did suffer an adverse employment action, and that adverse employment action was causally connected to him taking FMLA leave. Under the FMLA, the district court erred in determining that Mr. Keating's demotion did not rise to the level of an adverse employment action. As applied in Malia, the test in determining whether or not an adverse employment action exists is whether or not the change in employment position would dissuade a reasonable person in a similar situation from exercising their protected right. The 1st, 7th, 9th, 10th, 11th, and DC circuits all define adverse employment action broadly. In Collins v. State of Illinois, the court determined that although there was no reduction in pay or benefits, the fact that an employee was removed from a job she loved, she no longer had an office or a phone, and she was uncertain of her job responsibilities, all those were valid considerations in determining an adverse employment action.
Counsel, I want to be sure that we're operating under the correct standard of review. Now you've asked us to take a de novo standard of review, is that correct?
Yes, it is.
It seems to me that the district court, in making its finding, and it's the finding that you quoted, that was to constitute an adverse employment decision because such a change would not be sufficient to convince a reasonable person to refrain from exercising FMLA rights. That seems to me to be a fact question, is it not?
The district court determined that there were some factual findings. However, the factual findings are not at issue on appeal. We are here to discuss the legal conclusions, and this mixed question of law is determined under de novo, as applied in, or as determined in Vlahos v. Zipolitos.
Okay, we may get to that in a while, but that you may proceed.
So when you're talking about a reasonable person, are we to use an objective standard or a subjective standard in determining whether it had an adverse impact?
It is an objective standard, Your Honor. Most questions of law and fact, as determined here, are mostly from an objective perspective, along with like cases of tort, and in this case as well, it's an objective standard.
So did your client lose telephone privileges? Did your client not understand his job responsibilities?
We would argue that not having your own telephone or not having your own desk is similar in our case because Mr. Keating did not have his own classroom, he did not have his own students, and he did not have his own desk to prepare for his classroom.
But he's paid the same.
Yes, Your Honor, he is paid the same, and there were no reduction in his benefits as well. However, in Collins v. State of Illinois, the court determined that not having your own desk, not having your own phone, uncertainty of job responsibilities, along with, although there is no reduction in pay or benefits, those are sufficient and valid considerations in determining an adverse employment action. And that court held that those were enough to constitute an adverse employment action. In our case, Mr. Keating, too, was removed from a job that he loved and enjoyed. He no longer has his own classroom or desk, and he's uncertain of his job responsibilities in the sense that he now is a recess monitor, and this was not outlined in his position as a floater. It just sort of happened that way, as evidenced on page 17 of the record. In addition, in DeCampley v. Corman, the court determined that differences must be materially adverse to qualify as an adverse employment action. Ultimately, the court in that case determined that the employee did not provide objective evidence to satisfy that requirement. However, in our case, we do have objective evidence. On page 37 of the record, Mrs. Hodge indicates that floaters are younger teachers with less experience. Floaters do not have their own classroom, they do not run parent-teacher conferences, and they do not conduct state tests. They are also evaluated differently from classroom teachers. If the school's proffered goal in having performance reviews is to ensure that they promote and advance the right people, it would suggest that having different evaluation standards for both floaters and classroom teachers, that would suggest that they would be different positions. In addition, the school does take actions against those teachers who have subpar performance evaluations. However, in the past, those teachers have been required to attend a continued education course. However, Mr. Keating was demoted to a floater. In addition, Mr. Keating has diminished influence in the workplace. There's evidence in the record on page 19 that suggests that when floaters express their opinions or suggestions in school meetings, that other teachers roll their eyes. In Ray v. Henderson, the court said that diminished influence in the workplace is sufficient to establish an adverse employment action.
How do you measure that? How is that material? If someone rolls their eyes in the workroom, is that material?
We would argue that because, as determined in Ray v. Henderson, that it would suggest that it's diminished influence in the workplace. Floaters' opinions are not taken into consideration, and the fact that other teachers view them as second-class citizens, which is also in the record, would suggest that they do have diminished influence in the workplace, which would then qualify as materially adverse.
And isn't that a factual question? Isn't that what the district court determined was as a matter of fact, that he did not rise to the level of an adverse employment action?
Yes. However, we would argue that it is the application of the law to these facts that the district court erred in determining, which is reviewed de novo.
Okay, so you're saying it's not a question of fact?
No, it's not a question of fact. It's whether or not those facts would qualify as an adverse employment action. The second prong, or the third element of the prima facie case for a retaliation claim is causal connection. To establish causal connection, an employee must prove that the adverse employment action and the taking of the protected right, Mr. Keating's taking of FMLA leave, was not wholly unrelated. The burden of proof at the prima facie level is minimal. The close temporal proximity is sufficient to establish a causal connection. In Singfield, the court determined that 3 months was sufficient to establish a causal connection. Although courts are varied in determining what qualifies as a temporal proximity, they have gone from saying that 2.5 weeks is sufficient to 3 months is sufficient. We urge this court to consider the circumstantial evidence, which is also a component in determining whether or not there was a causal connection. Types of circumstantial evidence that courts review are ambiguous statements, suspicious timing, discrimination against other employees, and other evidence to suggest that there was discriminatory intent towards the plaintiff. In our case, Mrs. Hodge has made several comments about how she does not like when employees or teachers take FMLA leave. She says although there is nothing she can do legally to stop Mr. Keating from taking FMLA leave, she wishes she could. In addition, she mentions that FMLA handcuffs the educational process and hurts students. Mr. Novak, another classroom teacher, overheard Ms. Hodge indicating that she says that FMLA leave interrupts the learning process. Ultimately, she was disappointed she was taking leave, and we would argue that her ambiguous statements suggest that she had discriminatory intent against Mr. Keating for him taking FMLA leave. In addition, the second element is met as well, the suspicious timing. Mr. Keating took leave 2.5 months. Mr. Keating was demoted 2.5 months after he took leave. In addition, after 19 years of Mrs. Hodge giving Mr. Keating the highest mark on the performance evaluation, far exceeds expectation, in just 1 year after he took FMLA leave, she rated him at the lowest mark on the evaluation sheet. Far exceeds.
Isn't the standardized, how the kids perform on the standardized testing, that's not something that she can manipulate, is it?
No, it is not, Your Honor. There are 3 parts of the performance evaluation. 2 parts are objective, 1 part is subjective. The objective parts are standardized test scores of Mr. Keating's students, and the other portion are the future performance of his students. In addition, there is an in-class performance evaluation conducted by Ms. Hodge herself.
What about the 2 objective parts? How did he do in those?
Mr. Keating met the satisfactory level for 1 objective component, but was below expectation for the other component. He was also below expectation for the in-class evaluation, which was conducted by Ms. Hodge, which would suggest that there was 1 part that was objective and the other part that was subjective. In addition, the performance evaluations are compiled in the month of February. Mr. Keating received his contract renewal in March 15th. During that time, Ms. Hodge provides a recommendation to the board based on her evaluations. So it would suggest that it's not just the performance evaluation that the school takes into consideration when determining placement for the teachers. It is also her recommendation. And Michelle Hodge has known Mr. Keating for 19 years. She knows what he's capable of. In the past, she's rated him as far exceeds expectation. In determining whether or not an employee is competent and capable of performing well, the court must, in Edie, the court determined that the employee must show that they are competent and capable of performing their job to establish quality performance. All Mr. Keating had to show that he was capable and competent of doing his job. When Michelle Hodge made the recommendation, she could make that recommendation in part based on the performance evaluation, but also based on her 19 years of experience with Mr. Keating. There's also a human element to this, Your Honors. Mr. Keating has had parents who have called the school requesting that their child have Mr. Keating as a 4th grade teacher. These parents have called in kindergarten to request him. In essence, what the school is doing is reducing his 19 years of exemplary performance, all of the teaching awards that he's received, to mere check marks on a page.
Counsel, was there any evidence that he was treated any differently than any of the other instructors when he was demoted?
Yes, Your Honor. Mr. Matthew Novak, another classroom teacher who teaches at Welton Elementary, he received subpar evaluation scores on his performance review, and he merely had to attend a continued education course.
His was limited to just one subject area of teaching, though, as opposed to your client who had, I believe, math and science.
That is correct, Your Honor. However, Mr. Novak's performance reviews were in the subpar performance evaluation were in the 2 objective areas, in the standardized test scores, along with the student performances in future classrooms. Mr. Keating's, although one was met satisfactory, the satisfactory level, his 2 were in the one subjective, the in-class evaluation, and the objective evaluation. In addition, other teachers at Welton all know when the contracts come out, they all kind of discuss, and it's understood that if you do perform below par, that you would have to attend a continued education course.
But was the Novak situation a one-time deviation, or is that some type of course of conduct that the school district was exercising?
All evidence in the record suggests that any teacher who did not perform to the requisite standards was subjected to a continued education course. It is Mr. Keating alone who was demoted to a floater. In addition, Mr. Keating asserts that he has less advancement opportunity. However, and which is true, floaters are less or younger teachers with less experience. In fact, the only floater that has been promoted to an administrative position was Sophia Dorcat, who was promoted to vice principal. However, the evidence in the record suggests that she was related to someone on the board. Your Honors, today I have discussed how Mr. Keating did in fact satisfy the second and third elements of the prima facie case. He did suffer an adverse employment action, and that adverse employment action was causally connected to him taking FMLA leave. Your Honors, I see I'm out of time. May I finish?
You may.
We respectfully request that this court reverse and remand the lower court's determination and find in favor of Mr. Keating. Thank you.
Thank you, Ms. Sharma. You may proceed.
May it please the court, your honors, opposing counsel. My name is Sean Danehey. I am representing the interests of the appellant, Mr. Keating, and I will be addressing the First Amendment claims. I will be discussing how the district court erred in finding that the safe class did not violate Mr. Keating's First Amendment rights. First, I will provide a brief overview of the safe class. Then, I will discuss 3 different reasons why the safe class does qualify for strict scrutiny. First, because the safe class is not neutral and generally applicable. Second, because the safe class provides secular exemptions and denies religious exemptions. And third, because the safe class affirmatively compels Mr. Keating to violate his religious beliefs. And finally, I will show how the safe class does not pass strict scrutiny. And accordingly, we respectfully request that this court reverse the district court's finding and hold that the safe class did violate Mr. Keating's First Amendment rights. First, the safe class, which may be found on page 10 of the record, required the attendance of Welton employees at one of 2 two-day seminar programs. The first day involved the teaching of hand-to-hand combat, which was actually practiced during the course. The second day involved firearm education. The participants went to a firing range where they handled and even fired the weapons. The safe class also included the teaching of various methods that teachers could use to keep children calm during a crisis. The safe class exempted individuals who were pregnant, elderly, disabled, substitute teachers, or staff. The district court erred.
Counsel, which part of the safe class violated his sincerely held religious belief? Did one or both of them?
You mean day-wise?
Yeah.
The
I
first
mean,
two,
hand-to-hand combat versus the firearm training.
both of those would violate his religious beliefs because his religious beliefs were anti-violence. The part of the safe class that was not against his religious beliefs was a part where he could learn tactics for helping to keep children calm during a crisis, whereas his Catholic beliefs were nonviolent and therefore taking part in behavior that required him to fight hand-to-hand with an individual or fire a weapon of violence violated his religious beliefs.
Is nonviolence actually a tenet of the Catholic religion?
Your Honor, I am not well versed in Catholicism, so I can't answer that question perfectly. In the record, the Catechism would suggest that nonviolence is a tenet of religion. However, isn't
this a religion that sponsored the Crusades?
Yes, Your Honor, and that would definitely seem to hurt the case. However, as stated in Thomas, whether or not the religious belief is shared by the entire sect is irrelevant for whether or not it poses a substantial burden upon an individual's religious beliefs. Therefore, that substantial burden can still qualify even though Catholics took part in a few violent behaviors. Now, the district court applied rational basis scrutiny because they found that this law was neutral and generally applicable. Neutral and generally applicable is defined in Blackhawk v. Pennsylvania. Neutral. A law is neutral if it does not target religiously motivated conduct on its face or as applied. General applicability. A law fails the general applicability standard if it burdens a category of religiously motivated conduct while failing to reach or exempting non-religiously motivated conduct that undermines the purpose of the law to at least the same degree. We find an example of a law that is not neutral and generally applicable in Hialeah. In Hialeah, the city passed a number of ordinances that prohibited the ritual sacrifice of animals. These ordinances amounted to a flat prohibition on all Santeria ritual sacrifice. The court stated that because these ordinances pursued the city's interest only against religiously motivated conduct, that they were not neutrally and gen applicable. The ordinances failed to reach substantial categories of non-religiously motivated conduct that undermine the purpose of the law.
Is that different though? Because in that situation, you have a law that bans a certain activity, whereas with the SAFE class, it's requiring involvement in a certain activity.
We would argue, Your Honor, that makes it worse. Or rather, it is largely irrelevant, because as the court has stated, if it affirmatively compels or denies, meaning that if it requires a performance versus whether it denies or it forces the individual to not take part of it, it can still qualify as a burden or as non-generally applicable. Now, as stated, the court in Hialeah found that this law was not neutral and generally applicable because it failed to reach these non-religious ordinances. And such is the case with the SAFE class. The SAFE class provides substantial exemptions for non-religiously motivated behavior that undermine the purpose of the law. These exemptions undermine the purpose of protecting children. After all, the purpose is not protecting some children. And these exemptions guarantee that there are classrooms that receive no protection whatsoever. As found on page 26 of the record, for example, providing an exemption for Mr. Lambo because he was in a wheelchair saw to it that his classroom received no protection at all. Furthermore, even if Mr. Lambo was absent from school, the SAFE class exempted substitute teachers. Therefore, the classroom still received no protection. Imagine having to tell the parents of one of these children that the SAFE class had provided protection for every other classroom, but not theirs. This establishes that the SAFE...
Counsel, what's the other side going to argue in exempting substitute teachers or staff members, for example? What's the best argument to be made? What was the policy behind that from the school district's perspective?
For providing exemptions for the first three, they argued that they were incapable of performing the activities that were taught during the SAFE class. However, this is not a valid reason because, as stated before, the SAFE class still taught various methods for keeping children calm during a crisis. And these individuals were still perfectly capable in taking part in these activities.
Well, are you arguing that your client wants to go to part of the SAFE classes and not the entire SAFE class?
Absolutely, Your Honor. Mr. Keating was a dedicated teacher. He would have liked to learn techniques to help protect these children if they would not have violated his religious beliefs. In fact, he requested that he be able to take part in these nonviolent aspects of the case. However, Welton refused that request. It was an all or nothing class. You could not take one piece here and not the other two. Therefore, Mr. Keating was not allowed to take the part that he could employ, but not take part in a part that violated his religious beliefs.
How does this actually violate a nonviolent religious belief? Was he actually required to do any violence to anyone?
During the class?
Yes.
Yes, they were. As stated, they practiced the hand-to-hand combat during the course. Now, it was slowed down or taken easily during the course, but it was still taking part in what would amount to hand-to-hand combat between individuals.
Isn't the school policy consistent, though, when you talk about those excluded people and you say, well, they could have gone to certain parts of it, but the school board said, no, it's an all or nothing deal. And that's exactly what they said to Mr. Keating as well. No, you can't take some. It's an all or nothing deal.
Yes, Your Honor, that is correct. However, the drastic difference between the two is that these individuals were allowed to keep their job. Mr. Keating got fired. These individuals were exempted. They were provided that ability to not attend and still maintain their employment.
But the first group of three were physically unable, as opposed to Mr. Keating, who was unwilling because of his religious beliefs. Do you see a difference in that?
Yes, there is a difference in some cases. By providing an exemption for a pregnant woman, she's not always going to be incapable of protecting her children. She will be able to provide a level of support or protection after she is no longer pregnant. Furthermore, the SAFE class, or the approach towards exemptions, does not require that we compare Mr. Keating's circumstance to one single exception. We can do that, or we can compare Mr. Keating's religious beliefs to the secular exceptions that were applied as a whole. Therefore, the entire undermining of the purpose that was created by these exceptions as a whole must be compared to the level of undermining that Mr. Keating's exceptions would have created. Therefore, when you take it as an entire whole, we have substitute teachers who are physically capable. We have pregnant teachers, handicapped teachers, or elderly teachers who are capable of doing the parts where they keep the children calm. And staff is just as physically capable as the substitute teachers. And this provides at least the same amount of undermining of the purpose as Mr. Keating's exemptions would. And this establishes that the law is not generally applicable and therefore requires strict scrutiny.
How generally applicable is generally applicable? Can there be no exemptions whatsoever?
Not necessarily. If the exemptions have no bearing on achieving that state interest, then the state is not required to extend those exemptions for the religious reasons. However, these exemptions do have bearing on achieving the state's interest of protecting children. Therefore, they will be required, and that's even if you find that the law is neutral and generally applicable. This, as stated, the providing rational basis scrutiny to this law is correct following Smith. However, there are still exceptions to this rule, and the exception that applies in the present case is laid out in Bowen v. Roy. Bowen v. Roy states that if a neutral and generally applicable law provides secular exemptions but refuses religious exemptions, it is subject to strict scrutiny. The presence of the secular exemptions with the refusal of the religious exemptions suggests discriminatory intent and therefore requires strict scrutiny. We find an example of this in Fraternal Order of Police v. City of Newark. In Fraternal Order, the police department adopted a no beards policy. However, they provided a series of exemptions, some for medical reasons, from taking part in this no beards policy. The court stated that the presence of the secular exemptions, the medical exemptions, with the refusal of the religious exemptions, suggested discriminatory intent and therefore required strict scrutiny. Such is the case in the present case as well. Some of these secular exemptions even qualify as medical exemptions, which is identical to the exemptions in Fraternal Order. And when Mr. Keating requested an exemption based on his religious hardship, the school denied his request. This establishes that the case did provide secular exemptions and did refuse religious exemptions, and therefore qualifies for strict scrutiny.
Counsel, isn't there kind of a sliding scale when you compare religious exemptions versus secular exemptions? For example, there may be some type of basis to exempt teachers with impaired extremities or pregnant teachers or those over age 65, but maybe not for substitute teachers and staff members. In other words, can you just say you can't compare the secular exemptions versus the religious exemptions, or is there a sliding scale?
I'm sorry, Your Honor, I am not aware of a sliding scale. However, I do believe that that would be one of the dangers that they are worried about with free exercise clauses, because by providing a sliding scale, you would be inviting the state to make value judgments upon one's religious belief versus one's physical beliefs. And that is the danger that the courts want to avoid by applying a sliding scale.
So that was Justice Scalia's rationale behind the employer division versus Smith. Is that what you're arguing?
I don't remember. I'll take your word it was Justice Scalia, but yes, that is what I'm arguing. Okay. Now, under strict scrutiny, the safe class does not pass. Strict scrutiny, as defined in Smith, states that when a law burdens religion, it must show that it has a compelling state interest and that the means are narrowly tailored to achieving that state interest. And as further defined, narrowly tailored requires that the means be the least restrictive means possible for achieving that state interest. We have evidence within the record that shows that this is not the least restrictive means for achieving the state interest. Bill Rawls, the teacher of the safe class, as well as a former policeman, establishes a list of alternatives, which is supported by Michelle Hodge, the principal. And every one of these alternatives, which may be found on page 26 and page 40 of the record, would be less restrictive on religion than the safe class. This establishes that the safe class was not narrowly tailored to achieving the state ends and shows that the safe class fails strict scrutiny. Therefore, we respectively request that you reverse the district court's finding and hold that the safe class did violate Mr. Keating's First Amendment rights. Thank you, Your Honors.
Thank you. Appellees, Mr. Pearson, are you prepared? You may proceed.
May it please the court. My name is Skyler Pearson, and I, along with my co-counsel, Kraig Hamit, represent the Springfield School District, Welton Elementary, and Michelle Hodge, the appellees in this matter. I will be addressing the Family Medical Leave Act issue, and my co-counsel will address the free exercise issue. At this time, we'd like to reserve 1 minute for rebuttal. Your Honors, even under a de novo review, this court should affirm the district court's decision dismissing the appellant's FMLA retaliation claim for 2 reasons.
So I take it you're conceding that this should be a de novo review?
Yes, Your Honor. For 2 reasons. Number 1, appellant's reassignment from a classroom teacher to a floater was not an adverse employment action. And number 2, there exists no causal connection between the appellant's reassignment and his FMLA leave. The appellant must satisfy both of these elements conjunctively, and if either of the elements are missing, which both are in this case, this court should affirm the district court's decision dismissing the appellant's FMLA retaliation claim. Title 29 of the United States Code, Section 2611, specifically outlines what the Family Medical Leave Act is generally. In Section 2615, the FMLA outlines certain actions that employers cannot take against their employees. Traditionally, courts have looked to other discrimination cases like Title VII claims to determine if a retaliation has actually occurred. The First Circuit in Hodgins versus General Dynamics Corporation utilized what has come to be known as the McDonnell-Douglas burden shifting analysis to determine if an adverse employment action has occurred. An employee claiming retaliation bears the burden of these 3 essential and again conjunctive elements before the burden would then shift to the employer. Opposing counsel correctly outlined that the 3 elements are 1, the appellant engaged in protective leave, 2, the employee suffered an adverse employment action, and 3, there is a causal connection between the leave and their reassignment. Your Honors, in this case, the last 2 elements are missing. The United States Supreme Court in Burlington Northern and Santa Fe Railroad versus White determined that an adverse employment action has occurred when a reasonable employee is likely to be dissuaded from exercising his rights. Although that case was a Title VII claim, the courts, specifically the Second Circuit in Malia versus Metro North Railroad, determined that this same standard can be applied to FMLA retaliation claims. To determine in this case if the appellant has suffered adverse employment action, again, it is noteworthy that this is an objective test, as Justice Riedmann correctly pointed out when opposing counsel was speaking. We asked the court to consider the Second Circuit decision in Vlahos versus Cepelitos. In that case, Your Honors, a chief nursing assistant was taking FMLA leave. Before she left on FMLA leave, her entire department and her position were done away with. So obviously, when she came back from FMLA leave, she had to be reassigned not only to a different department, but to a different duty. In determining that no adverse employment action existed, the court focused on the essential job duties that she performed both before and after she returned from FMLA leave.
Did the court focus on the fact that the entire department had been wiped out?
The court did not. They did take notice that the entire department had been wiped out, but again, Your Honor, the court focused specifically on the fact that her essential job duties of both before and after were primarily based in research, and the court did focus also on the fact that her pay and her benefit levels did not change at all. Because of that, the court determined that no adverse employment action had taken place. Like the case in Vlahos, the Fifth Circuit also in Hunt versus Rapides Healthcare System, LLC, went so far as to say that changes outside of pay, benefits, and essential job duties will never rise to the level of what could or would dissuade a reasonable employee from taking FMLA leave.
How do we determine what is the essential job duties of a teacher?
The essential job duties of a teacher, Your Honor, is to be able to stand up in front of a class of students and be able to teach them.
According to what? How do we determine that that is the essential duty?
The courts, Your Honors, determine that basically the ability of, like in Vlahos versus Zepolitos, her primary duties were research related, and both before and after she came back. In this case as well, his primary teaching abilities were utilized both before and after his leave. He was still able to stand up in front of a classroom of students and teach.
It seems from reading the record that certainly Mr. Keating found his job duties to be more than just teaching basic reading and writing. His was a connection with the students and forming these elementary children into people as a whole, not just academically, but socially. And that the support from Mr. Novak, I think, testified as well, that that is an important part of teaching.
Speaking, Your Honor, to Mr. Keating, the appellant's feelings, on page 19 of the record, although he does say that everybody knows that it's a demotion, and on page 28 of the record, he says he didn't feel like a teacher anymore. That is not the test that this court should utilize. Again, this is an objective test. Mr. Keating's feelings and how he thought his job duties changed is not for this court to determine. This court is to determine under a reasonable person standard and not an objective standard that an adverse employment action has not occurred.
Does Mr. Novak's testimony add credence to that being a more objective than purely subjective?
Mr. Novak, on page 31 of the record, testifies that he would be upset if he were switched from a classroom teacher to a floater. However, he does not testify that he would be dissuaded from taking FMLA leave if he were changed. Likewise, on cross-examination on page 33 of the record, he states that he does not regard floaters in any less of esteem than he does regular teachers. So that would indicate that his testimony does not rise to the level required by an objective standard to meet an adverse employment action.
So I take it your argument, is, Mr. Pearson, is that as long as he receives the same pay, the same hours, the same benefits, and he can stand up in front of a class and breathe oxygen, then there's been no adverse employment decision.
That is not only my argument, Your Honor, but also what courts have determined to rise to the level of an adverse employment.
How do you distinguish cases like Wanamaker versus Westport Board of Education or Hyde versus KB Holmes where they will consider other factors such as loss of prestige, lack of career advancement, that their duties have changed in essence, as Judge Riedmann has asked you?
Again, with going to the duties, his essential job duties did not change. While the appellees do concede that certain elements of his job did change, as opposing counsel correctly pointed out, those would not rise to the level that courts have determined to equal an adverse employment action.
So are you using kind of a totality of the circumstances? I mean, when you take all of those circumstances,
Correct, Your
it
Honor.
doesn't arise?
Yes, Your Honor. Nothing, again, in the record, Your Honors, displays that a reasonable employee would be dissuaded from taking FMLA leave at Welton Elementary. Because the appellant has failed to satisfy that he has suffered an adverse employment action, this court should affirm the lower court's decision dismissing his FMLA retaliation claim. However, the appellant's FMLA retaliation claim is also deficient when it comes to the third essential element that he bears the burden to prove, and that is that of a causal connection. Although the appellants rely on the language from the court that the two cannot be wholly unrelated, which seems like a minimum standard, this has been significantly narrowed by courts. The Sixth Circuit in Polk versus Yellow Freight System Incorporated and the Southern District of Ohio in Hunt determined that with regards to the causal connection, the leave must constitute a significant factor. The reason, Your Honors, and indeed the significant factor why Mr. Keating was reassigned from a classroom teacher to a floater was because that was the position he was best suited for. On page 8 and 9 of the record, it indicates that Mr. Keating had received poor reviews in both being able to teach math and science effectively. The reassignment of him being able to now focus on reading and history are the best of both worlds for both he and the students that he stands up and teaches.
Why not provide him with the same opportunity that was provided to Mr. Novak?
Mr. Novak was able to take continuing education classes and stay in his same position. However, Mr. Novak's evaluation was borderline at best, although he was struggling very little with one subject area. Mr. Keating is now struggling with 2 subject areas and is significantly subpar to the standards that the school district wants him to be at. And although the appellants rely on the temporal proximity to show that a causal connection exists, the timing is actually, Your Honors, not important in this case. Page 21 of the record shows that the appellant was aware of the history of how this timeline works. In February is when the teacher evaluations would come out every year. Mr. Keating had been at Welton Elementary for almost 2 decades. He was well aware of this. In March, his employment contract would come out. The Appellees, and indeed Mr. Keating himself, had no control over when he would be needed to take sick leave to care for his mother. And it is purely happenstance that it coincided with when his evaluation and his contract would come out.
Are you agreeing, Counselor, then that 2 months is a sufficient time period?
We would concede that 2 months would be a significant time period to be able to establish that. However, we would again state to Your Honor that this is a conjunctive test and a finding that this court, that he did not satisfy an adverse employment action or that he did not show a causal connection, then the district court's decision should be affirmed. As to the circumstantial evidence in this case that was pointed out by opposing counsel, although Principal Hodge has stated that she dislikes FMLA leave because it significantly hurts the process of students to learn in their own classrooms with their own teachers. Page 34 of the record indicates that there is no history of retaliation. Although she has this belief that FMLA leave does hurt students and the process of learning, this dislike has never rose to the level to take discrimination against employee. Page 31 of the record, Mr. Novak states that one teacher took FMLA leave and returned and is still teaching at Welton Elementary today.
Just because you've never discriminated before, does that mean you get a first bite at the apple?
That would, Your Honor, that would mean that it would not be in the character of not only Principal Hodge, but also the school district who made the ultimate determination as to the reassignment of Mr. Keating to show that no causal connection existed. Your Honors, no retaliation has taken place in these facts because the appellant has failed to show that a reasonable employee would be dissuaded from taking FMLA leave at Welton Elementary. Appellant failed to show that he suffered an adverse employment action because his reassignment from a classroom teacher to a floater did not affect his pay, his benefits, or his essential job duties. Likewise, appellant has failed to satisfy that the third element of causal connection. I see that I'm out of time, Your Honors. May I finish?
Conclude briefly, please.
His reassignment of poor teaching evaluation did not rise to the level of an adverse employment action and was not causally connected. Because the appellant has failed to satisfy 2 of the 3 required elements of this conjunctive prima facie case, we respectfully request that the district court's determination be affirmed. Thank you.
Thank you, counsel.
May it please the court. Good evening, Your Honors. My name is Craig Hamit. And as my co-counsel indicated, we represent the Springfield School District and Welton Elementary. Now we'll be discussing with you the free exercise issue with regard to the safe class requirement. We request this court affirm the trial court's decision for 2 reasons. First, the regulation set forth is facially neutral because it does not target religiously motivated conduct in its text or as applied to the appellant. Second, the regulation is generally applicable because even though it makes exceptions, they do not undermine the purpose of the regulation, and officials do not exercise any discretion in applying the law. We ask this court to subject the regulation to rational basis review based on these facts. Under this review, the regulation should be upheld because child safety is a legitimate state interest and the safe class is rationally related to that interest. However, even if this court were to determine that this regulation should be subject to strict scrutiny, you should still uphold this regulation because child safety is a compelling state interest and the safe class is narrowly tailored to that end. Therefore, under either a rational basis review or strict scrutiny, this court should affirm the trial court's decision to uphold the regulation. Your Honors, this case is about an elementary school taking reasonable steps to protect the lives of innocent children and prevent tragedies like Columbine, Virginia Tech, Sandy Hook, and last Monday's shooting in Sparks, Nevada. This case should be analyzed under the Supreme Court's decisions in Employment Division v. Smith and Church of the Lukumi Bablu I versus City of Hialeah. In addition, 2 cases from the Third Circuit, authored by then Circuit Judge Samuel Alito, are particularly instructive in this matter. They include Fraternal Order of Police versus City of Newark and Black Hawk v. Pennsylvania. Under this approach, courts look for 2 things. First, courts determine facial neutrality because if a law seeks to burden religiously motivated conduct on its face, a court need not go any further before demanding a compelling state interest. Second, courts determine general applicability because an official action that targets religiously motivated conduct for distinctive treatment cannot be shielded by mere compliance with the requirement of facial neutrality. In this first step of determining facial neutrality, courts look to the text of the regulation and see if it can be applied in a neutral way. A minimum requirement of neutrality is that a law not discriminate on its face, and a law lacks facial neutrality if it refers to religious practice without secular meaning discernible from the language or context. The criminal regulations in Smith, the no beard policy in Fraternal Order, and the Game and Wildlife Code from Black Hawk were all deemed to be facially neutral because they did not target religiously motivated conduct in the text of the regulations. The court in Hialeah, however, took a step back and looked at the regulations as a whole and determined they were not facially neutral because the ordinance's various prohibitions, definitions, and exemptions took great care to gerrymander the religious killings of animals by those Santorian church members and exclude almost all other killings of animals, including hunting, fishing, the use of rabbits to train greyhounds, and butchers. Exhibit B at page 10 of the record is the addendum to the employee handbook that requires the safe class. If you read it, you will notice nothing in the text of the regulation targets the appellant or his religious beliefs, or any religious beliefs for that matter. As stated in the text of the regulation, and according to Principal Hodges' testimony,
If it doesn't explicitly target pacifists or people who hold religious views about violence, it certainly does, the effect of it is targeting them, is it not?
No, Your Honor. The effect of the regulation is to ensure student safety. That's the effect of the regulation, and the impact that it's had on the appellant is only incidental.
Well, if that were true, what is the possible rationale to exclude substitute teachers and staff members who are perfectly physically capable and in fact probably would be the first responders?
Facial neutrality is not determinative, and courts do look to general application to decide.
It may not be determinative. It's an 800-pound gorilla. Is it not?
That is correct. It must satisfy both of these to pass under rational basis review. In regard to the substitute exemption, courts look at individual and categorical exemptions to determine if they undermine the purpose of the regulation to at least the same degree as would a religious exemption. Opposing counsel cited Fraternal Order of Police, which is right on point. The 2 Muslim police officers sought an exemption to the City of Newark's no beard policy for their uniformed police officers. And they were not granted a religious exemption where there were medical exemptions granted for other people. And the court held that the categorical exemption for medical reasons undermined the state's interest in uniformity of appearance to at least the same degree as would a religious exemption. However, the substitutes as a class exemption don't undermine the purpose of this regulation to at least the same degree as would a religious exemption for the appellant.
Tell me the reasoning there.
The substitute exemptions may be a default in the regulation. However, an exemption for the appellant would put students in his classroom at risk every single day throughout the entire school year. Substitutes are in the building 3 to 4 times a month based on the testimony from the record. And this, putting students at risk would be substantially lower than that of the students in the appellant. So the exemption for substitutes doesn't undermine the policy to at least the same degree as would an exemption for the appellant.
What about staff members?
Staff members, staff members, according to the record, are not in the best position to help children and ensure safety based on their physical location within the building, and as a class also do not undermine the regulation to at least the same degree as would a religious exemption. And it's just as likely that if there were a substitute in any particular classroom, a floater might be in that room as well. And as we've seen, the floaters are required to attend this class.
How do you address Mr. Danehey's argument of saying to a parent, I'm sorry, your child's teacher didn't have to take this?
Well, if I would never want to make that statement. We would prepare for the worst and hope for the best. The school's monetary concerns, budgetary concerns, limit the kinds of programs that can be implemented. And
But the school wasn't paying for this. The individual teachers were paying for it, weren't they?
that is correct. The teachers, the budgets were so tight that the teachers had to pay for these classes themselves. And the point is that the substitute exemption just doesn't undermine the policy to at least the same degree as would
The fact
the
that they
religion.
had to pay themselves, isn't that more offensive than if it simply were required and the school district was paying for it? Aren't you compelling someone to violate their religious beliefs and pay for it at the same time?
In this case, yes. But the exemptions that the opposing counsel targeted, like I said, don't undermine the policy to at least the same extent. The staff, courts also look at categorical exemptions that are sufficiently open-ended to allow interpretation by officials. And the staff exemption is not one of those that are sufficiently open-ended as to allow the kind of interpretation by the officials in applying the law. Because
What about the guidance counselor? They weren't able to determine whether the guidance counselor is in fact a teacher or a staff member. I'm not sure how I would determine that.
The text of the regulation, the people who fall under this staff exemption logically flow from the text of the regulation. The regulation sought to ensure student safety in the classrooms and anywhere within the building that students should be on a regular basis. So the regulation sought to target teachers and administrators who would be in the school's office that would have interaction with students on a regular basis. The staff in this instance wouldn't have as much interaction with the students on a daily basis, but the guidance counselor was not a staff member because he had the kind of interaction with students that was closer to that of a
What about
teacher.
the athletic director that's a substitute teacher every once in a while for the health class?
The substitutes, the teachers are not, they're exempt from requirement, but they're not forbidden from attending the class. So the people who wished to be there could attend the class if they so chose.
And I don't mean to run you down a rabbit trail, but the question is whether this is a generally applicable law, and I need to be convinced that this is a generally applicable law.
Well, and courts also look at individual exemptions. And as opposing counsel mentioned, John Keating sought an exemption to the second day of the class because of his religious beliefs. Principal Hodge denied this, and as this would have been exactly the kind of individual exemption that would have been violative of general applicability. It's this evidence that is, it's directly evident of the district's intent that this law be generally applied. In looking at categorical and individual exemptions, this usually leads to the discretion by officials that undermines the purpose of general applicability, because it creates a scenario where officials can determine that religious reasons for violating a law are not as worthy as secular reasons for violating the same law. Courts take particular notice when those exemptions are for hardships or for extraordinary circumstances. But SAFE does not allow for discretion by officials, as I've stated, because there was no formal waiver process, and any of the communications with Maggie Finn, the board member, do not rise to the level of discretion. Principal Hodge was really just double checking that the people who fit into certain categorical exemptions was correct. Therefore, this regulation is both facially neutral and generally applicable and should be subject only to rational basis review, as the lower court did. However, even if this court were unpersuaded by my arguments and were to subject it to strict scrutiny review, you should still uphold this regulation, because child safety is a compelling state interest, and the SAFE class is the most effective way to ensure student safety in the classroom. As principal,
Most effective, is that what we use, or where does the least restrictive?
the level of safety that the regulation sought to ensure, the SAFE class was the least restrictive means to achieve that level of safety. And
According to the gentleman who offered the class?
according to the district's determinations, based on the several types of security measures that they looked at. The district also looked at employing a full-time officer, getting a high-tech security system, a key card system with pre-approved access.
You said the district did look into that?
The district looked at several other options.
Those sound like pretty good options to me.
All of those were outside the budgetary limitations of the district, and for the district had the best knowledge of all of their own limitations that unfortunately just can't be conveyed to the court. For them to ensure the level of safety in all places, in all parts of the school where students should be on a regular basis, the SAFE class was the least restrictive means to do so, and it also happened to be the cheapest way to do so. Novak's testimony in the record also indicated that previous protection measures, such as locking the doors and having people check in, was really more aimed at keeping track of who was in the building rather than at preventing tragedies that the regulation sought to prevent.
What would happen if the staff member who was exempted under this policy, if the staff member would have to take the SAFE class? Wouldn't that accomplish the same thing?
I'm sorry?
The staff member that is at the front door to keep people out.
There's nothing in the text or from the record that would indicate that who would run like the greeting of parents and the dropping off of children. If you're saying that hypothetically if a staff member were at the front door, the SAFE class, there would be teachers and administrators there as well. A staff member wouldn't be out in front of, just logically, a staff member wouldn't be out there by themselves.
I'm suggesting that might be the least restrictive means, would it not?
But to ensure student safety at the level that this regulation sought to ensure, the SAFE class was the least restrictive means. There wasn't any other way that they looked at that would ensure safety to this level. The Supreme Court held that the right to free exercise does not relieve an individual of the obligation to comply with a law that is facially neutral and generally applicable. We therefore ask this court to affirm the lower court's decision that the SAFE class was facially neutral and generally applicable and thus subject only to rational basis review. However, even under a strict scrutiny analysis, this class was narrowly tailored to the compelling state interest of child safety. And therefore, we ask this court to affirm the lower court's decision. Thank you.
Thank you, counsel. Is there time for rebuttal? I'm sorry, I cannot see you. Okay.
Yes.
Advise counsel how much time, and they may proceed then.
1 minute.
All right. Counsel, you may proceed. You have 1.5 minutes.
Thank you,
may
Your Honor,
proceed, Mr. Danehey.
for the adverse employment action, it does require an objective standard of what a reasonable person in a similar situation would do. But to establish that, courts will consider smaller bits of evidence, sometimes subjective, such as Collins did, to better understand what a reasonable person would do. And in that case, it is imperative to remember that Mr. Keating taught for 19 years as an exemplary fourth grade teacher, and then was demoted to a position where he taught among new students fresh out of college with very little experience. Furthermore, the causal connection is not a conjunctive test. It does not require both the circumstantial evidence as well as the temporal proximity, which is established in Singfield, which held that the temporal proximity alone established a causal connection. And as far as the free exercise claim goes, the financial situation of the school does not need to be considered. That is not a consideration. If they couldn't afford to do the least restrictive means, they should have done nothing at all, because they did violate Mr. Keating's First Amendment rights. Therefore, Your Honors, we urge that this court reverse and remand the district court's holding on the FMLA issue and find that Mr. Keating did establish a prima facie case, and that you find that the safe class did violate Mr. Keating's First Amendment rights under strict scrutiny. Thank you, Your Honors.
Thank you, Mr. Danehey. And is there time for rebuttal?
Yes, 1 minute.
All right. Very well. Mr. Hamit, you may proceed.
Your Honors, in regard to the FMLA issue, the opposing counsel made it seem like the third element was a conjunctive test. That's not our argument. Our argument is that under the FMLA retaliation, the three elements are a conjunctive test, and without meeting any one of the three, the appellants failed their claim that there was a retaliation under the FMLA. And under the free exercise issue, the district couldn't do nothing. As a compelling state interest, it would be unreasonable to ask the district to do absolutely nothing to ensure child safety. And for these reasons, we ask this court to affirm the trial court's decisions on both issues.
Thank you, counsel. All right, you can all take a deep breath. We are done. This case is submitted, and I'd ask for a round of applause for That will conclude the oral arguments. We're going to take just a few minutes to do our scoring. We will be back with comments and results, but congratulations to oral arguments. Very well presented. Thank you. We stand in recess for a few minutes. Okay, you may be seated. Well, this is the time for results, but just like award shows, we're not going to tell you right away. We are going to make just a few general comments, and then we will announce the final results. I will say that the oral arguments on behalf of all four of you were just outstanding. I can see why this was the finals, so you are all to be congratulated. We're going to give you just some general comments as you go forward, and I think all three of us would say we will be delighted to have you in our courtrooms at any time, and hopefully soon. Okay. Chief Justice?
I will second that hopefully soon part. Well, great. I too have very positive things to say about all four of you. I thought you had a tremendous grasp of the case law and responded very well as to which cases were applicable in particular kinds of situations, which I thought was very good. Also, you had very good grasp of the record itself. You were all able to cite specific pages, more than one page in certain instances, and that showed me that you had done what is perhaps the most important thing in oral argument, and that is you had thoroughly prepared before you came here today, and you were able to respond very well. I thought you all got your main points out, and you had very good responses. So positive kind of thing. I think your hard work showed up, and I do look forward to seeing you in a courtroom near all of us very soon.
Thank you. Judge Riedmann.
I will just echo, you know, if you've ever watched, which you can't watch, oral arguments, because we stream them, this was a far cry above a lot of what we see, so thank you for your preparation. I thought everyone did a great job. The volume was great, the manner, the conviction that you had, whether you believed in the answers that you were giving sometimes or not, the conviction goes a long way. The humor, it's good to be able to have humor. And I think those are all signs of being prepared, which, as the Chief Justice said, is so important to us and which we sometimes don't often see. So I appreciate your preparedness for today.
Very good. And I would add the same comments. I look at style as well as the actual presentation. I thought for law students you were just outstanding. It's very important to be respectful to a court. You were all respectful. I mean, the questions can be pointed. They can be for you or against you, and you can turn them. But it's always very important to be respectful, to acknowledge and recognize the judge's question or the judge's position. And I thought all four of you did that very well. That is a skill that you're going to want to take forward. You're not always going to agree with the judge who's asking you questions, whether it's on an appellate bench or on a district court bench, but you must acknowledge and be able to distinguish the cases that are before you. And I think you did a very good job. In moot court competitions, I would say be careful about conceding positions. Now let me tell you, in real life, you do want to concede positions when it's reasonable to do so, because judges will expect that, and that's the proper thing to do. In moot court competitions, maybe not so much, you know. So I mean, if there are issues you know, in this particular case, that there were some issues on standard of review, you want to pick the standard of review that is most favorable to you and stand on it, whether or not that would happen in real life. And there were a couple of other concessions, but I thought you all did excellent. But there are certain things that you'll go back to your coaches and say, what can we or should we concede in a moot court competition versus what is real life? But I would say that we're all proud of you, and we will be looking forward to having you in our courtrooms. Okay, is there anything else from the judge's perspective?
I don't think so.
If not, I am going to announce the winners of the competition, and then for a few brief moments, if we don't bore you too much, we will open it up for questions if you have any questions of the judges, and then we will adjourn to the reception. So. First of all, the winning team in the moot court competition for 2013, and I will say this both for the winning team and for the top oralist. I've been through a number of these moot court competitions at the University of Nebraska and here and in a couple of other places. This was as close as I've ever seen. This was a very close competition and very well done. So I wish there was a 1A and a 1B, so you can consider that. But the winning team in the 2013 moot court competition is Sean Danehey and Shivani Sharma. And again, in very close fashion, from many perspectives, the outstanding oralist in this year's competition is Shivani Sharma. So, and with that stated, we will open it up just for a few moments for questions from either the panelists or anybody in the audience. Or if you think that it's Monday afternoon and time to go to a reception, we're fine with that too. Okay. Are there any questions? Okay. If not, thank you for attending today. Thank you for your participation. An absolutely outstanding job.